The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that, dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law, and this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case, 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case, and the only case, that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions. Just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned, here's a key point, in the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites C. Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so the motion is denied.
Thank you, Your Honor.